Long before Mumbai became the financial center of India, the coastal city of Surat was the epicenter of Parsi wealth and influence. In the 17th and 18th centuries, Parsi merchants built immense fortunes here through international shipping, textiles, and banking. As the British East India Company shifted its focus, those families began migrating south to the booming shipyards of Bombay. But they didn't simply abandon their home city. These departing families established massive charitable endowments in Surat, pouring their wealth into hospitals, schools, and housing to support the generations they left behind. Today, those very institutions are collapsing. The Surat Parsi General Hospital sits on prime real estate, yet 95% of its infrastructure sits idle. At the same time, valuable trust lands are facing illegal encroachment. While the funds for maintenance exist, a legal bottleneck prevents their use. The physical ruin of Surat's Parsi infrastructure is the direct material consequence of a static legal structure failing a changing demographic. That bottleneck is a single document signed on January 1, 1841, the Parsi Surat Charity Fund Trust Deed. Registered in Mumbai, this deed dictates that control over Surat's charitable assets rests with a board of trustees appointed for life. The local Parsi citizens living in Surat have zero voting rights and no mechanism to hold these absentee administrators accountable. For a century, this system operated without question. Then came January 26, 1950, when India adopted its constitution. Under Article 13, any pre-independence law, custom, or rule that violates the fundamental rights of Indian citizens is rendered void. In the Republic of India, pre-independence private trust deeds are subordinate to the Constitution, providing local beneficiaries with the statutory power to demand democratic elections. To understand why the system fails, look at the hierarchy. The Mumbai-based charity fund appoints Surat Parsi Panchayat trustees for life. Beneath them are Surat's actual beneficiaries. They have no power to elect leadership or demand financial transparency. When trust lands are encroached upon or a hospital sits idle, the people most affected have no structural way to intervene or recall the board. The current trustees argue that the Constitution protects the existence of religious and charitable institutions under Articles 25 and 26. That protection is limited to the existence of the trust. The administrative rules governing that trust are a legally distinct matter. When evaluated under Article 13, those 1841 administrative rules are subject to modern public policy. Private deeds that deny basic administrative fairness or violate modern transparency laws contain clauses that are now void and unenforceable. Preserving the charitable intent of an 1841 deed can be achieved without preserving its oligarchical administration, separating the core mission from an outdated power structure. Unaccountable trust administration has a tangible impact on the daily lives of the community, often manifesting in the way trustees wield exclusionary power. Consider the legal battle of Gul Rukh Gupta. After marrying outside the Parsi faith, she and other women were blocked by local trust leadership from entering the Tower of Silence to attend the funeral rites of their own parents. These exclusions vary wildly from city to city. What one trust allows, another bans, identifying these as administrative choices made by boards rather than absolute religious mandates. Interim court orders have already started forcing trusts to allow these women to participate in the rites, signaling a clear shift in how the law views trustee discretion. The Gulrukh case establishes that the administrative power of a trust is not absolute. When these rules collide with the fundamental rights of a beneficiary, the court has begun to prioritize the rights of the individual over the autonomy of the board. In Surat, the current Panchayat trustees are relying on one specific legal argument to block local elections. They claim that because the Parsi residents of Surat are not formally registered members of the trust, they lack locus standi, the legal standing, to demand voting rights. This defense is a misinterpretation of Indian trust law. The ultimate authority governing this dispute is the Gujarat Public Trusts Act of 1950, specifically Section 2, subsection 10. This law defines a person having interest, independently of any internal membership role maintained by a private trust. Any adult Parsi Zoroastrian residing in Surat is a legal beneficiary of these funds by birth and lineage. Other major institutions, like the Bombay Parsi Panchayat, updated their systems years ago to recognize this fact, giving every adult community member a democratic vote. Surat beneficiaries are legally empowered to participate in their own governance without seeking the permission of the current trustees. Under statutory law, beneficiaries possess independent legal standing to force institutional accountability, effectively circumventing the membership myth. Moving from theory to action requires the execution of a specific statutory procedure. The authority to rewrite these archaic rules lies with the Charity Commissioner. Under the Public Trusts Act, any two or more beneficiaries, or the Commissioner acting on their own motion, can file a formal petition to amend the administrative scheme of the trust. The legal burden of proof here is highly specific. Applicants must show that the 19th century arrangement has become impractical, obsolete, or prejudicial to the better management of the properties. A hospital operating at 5% capacity while its land is encroached upon provides clear evidence. Once obsolescence is proven, the Charity Commissioner has the explicit statutory power to alter the scheme and mandate elections. A 19th century administrative arrangement cannot legally lock out a 21st century community from basic administrative fairness if the correct statutory pathway is utilized. The 1841 Parsi Surat Charity Fund deed is a subordinate contract, subject to the laws of the modern republic. Reclaiming the community's ancestral infrastructure is the primary goal, restoring the crumbling dharamshalas and idle hospitals so they may serve the people they were built for. The tools to halt this decay exist right now, codified within the Constitution of India and the Gujarat Public Trusts Act. To reclaim these assets, the local community must mobilize as statutory beneficiaries and formally demand the creation of a local voter register. In the Republic of India, the right of beneficiaries to govern public trusts is a constitutional guarantee, ready to be enforced.